Okay, hi everyone. It's great to see you all. Welcome to this evening's event, which is From Startup to Scale Up Strategies for Growth. I can see quite a few familiar faces, which is very exciting, so welcome back. My name is Morgan Sheargold. I'm one of the practice leaders here in our corporate transactions team, which does everything from capital raising all the way through to full-scale M&A. And I'm joined by three of my lovely colleagues, Stephen, Helen and James, who I'll get to each introduce themselves, starting with Stephen.
Check that works. Hi everyone, my name's Stephen. I'm a practice leader at LegalVision in the commercial and regulatory team. So my specialty is sort of contracts and I guess sort of general compliance with regulations, particularly in those sort of niche license industries.
Hi, is this working? I'm Helen. I'm the practice leader in our tax team. I do work in the corporate space, so advisory on structuring and restructuring, business sales, and also other types of acquisitions, and also work closely with Morgan in our capital raising and transactions team. I also do a lot of personal structuring work as well. I'm also losing my voice, so hopefully it doesn't, makes it through tonight. Thanks.
I'm James True. I head up our employment team here at LegalVision. So from employment, we're sort of covering everything in relation to the employment relationship, from hiring people, everything through the life cycle of the employment relationship all the way to firing people. So everything that comes across that. And yeah, some of the things tonight is related to employment that I'll be talking about is how you can actually incentivize people in your team. So getting that right from an employment perspective.
Great, thank you. So as you can see, we've got a fairly broad expertise here, which we hope you'll all find valuable. So tonight we'll be going through the respective tips and tricks as lawyers, things we've seen, a couple of things that we have seen to please not do in the future. And then we'll take some questions at the end. And then afterwards, you are very welcome to stay and network. There are obviously drinks. I can see most of you found them already, which is good, and nibbles. So we look forward to that. In an interesting turn of events, the first question here is actually for me, so I'll answer my own question. So the first thing we're talking about is building a sustainable model. And I wanted to first touch on perhaps three corporate transactional pieces to this. I think typically when we talk about a sustainable business model, people feel like that's commensurate with things like operational scalability, revenue, but there are some really core things from a transactional point of view that we see as really important there. And the first one is governance arrangements. So it is more often than not we see no constitutions in place, no shareholders agreement, and those types of documents are really, really essential. And if you are looking to do an eventual exit or capital raising funding, those things need to be in place. So we always actively encourage the ancillaries to be good to go, if you will. And the second one, I would say, is around operational scalability. So again, people think of that in terms of infrastructure, but there's a really important piece there, which I know James will talk about, which is employees and incentivizing employees correctly under the terms of employee share option plans, and effectively giving them an opportunity to have a stake in the business, which equally can minimize your cash flow out from that. And then thirdly, I would say it's always around proven revenue and preparing yourself for an IPO and exit. And you might say, I'm so early, I'm not even thinking about an IPO or an exit, that's so far down the track. But having said that, the companies we see do the best from a sustainable business model point of view, and then eventually to exit, are the ones that plan their business from the very, very beginning with an exit pathway in mind, whether that's IPO, whether that's trade sale or a private sale, whatever it may be, and effectively build their business around the type of discipline and transparency that are required by those types of transactions. And then you have everything in place, and often it means you can meet the eventual rigor of the public market, which is very, very different, and or a potential trade sale, for instance, with an institutional investor. So those are three of the key things. But I am keen to hear from Helen. So Helen, first question to you, what structure do you think offers the most flexibility from a tax point of view for growth and expansion?
Morgan, it's interesting that you talked about planning and setting up your business with an exit in mind. So it actually is something I also think is really important from a tax perspective. Thinking about, what are your goals and intentions, and are you planning to exit? And if you are thinking of exiting, what does that look like? Is it that you're going to do a share sale or business sale, or you're looking to expand and then bring in investors and then slowly dilute yourself out? Each of them have different tax consequences. So thinking about, the type of structure from a flexibility perspective, I think thinking about exit, even though you're just starting a business and thinking about exit, it seems like a strange thing to do. But thinking about an exit when you're starting up is really important, because you want the ability, or setting up a structure that gives you the ability to have a flexible exit, and most tax effective exit as well. The type of structure that we generally see that gives you the best flexibility in running pretty much any type of business is a corporate structure. And the reason why we recommend these types of structures is because it gives you the ability to expand your business if you wanted to, set up multiple other types of businesses or diversify within your business, or you wanted to expand overseas, or you wanted to bring on investors, which is, what Morgan's talking about this evening, and bringing on funding, looking at different ways to fund as well. A corporate structure gives you that flexibility to offer your investors different ways to invest and fund your business. There are also lots of tax benefits in having a corporate entity. Some of them are like tax concessions that you get from the government, and some of them you may already know are R&D. So if you're looking at doing some research and development within your business, then there are tax concessions that are available, but that's only available to a company. When you are thinking of bringing on investors, there's also an early stage investor concession that's available to your investors as well, that you can only access if you have a company. So two really good concessions from the ATO's perspective are only available to companies. And then when we're talking about incentivizing staff, which James is going to touch on later on, with employee share schemes, again, a company offers that ability to offer those types of equity. There is, again, another tax concession for employee share schemes. So having a company, from my perspective, is a very common and great entity structure to be able to set up a business. And just noting also you have the corporate tax rate. Having a company gives you the ability to access that as well, as opposed to a sole trader entity or a trust structure.
Thank you so much. And I think you've just answered this, Helen, and we know how important tax is. But in terms of the key tax considerations, would you say it all starts with the right structure and everything really should flow from there?
Yeah, that's right. So some people set up a structure because they just start operating as a sole trader, or their accountants told them, to set up a trust because there's a certain discount you can access. Setting these structures up without getting the right advice on the type of business that you're entering into can mean that restructuring at a later time can result in a tax consequence for you or your entity that you've just set up. And it's just not a great, outcome, because you've just set this up, spent all this money setting it up, and now you've been told that you have to pay a bunch of tax to move it into another entity, which is more appropriate for your business. So I do recommend, before you start setting up your business, get the right advice and just think about, setting out the right structure before you start means that you don't have to deal with tax consequences later on.
And now, Stephen, so when we see companies go from startup, which is a bit more about survival and experimentation, to scale up, which is a bit more around expansion of a proven business model, what types of contracts do you see as essential for that scalability, and maybe some pitfalls and or personal experience around the things not to do?
Yeah, absolutely. So in terms of, I guess, essential contracts, to sort of two buckets. So one is the contracts that I guess relate to maybe the, R&D or the growth of the business. So that might be things, say, if you're in your software, contracts with your developers that are clear and concise and make it really clear who owns what. You wouldn't believe the amount of early stage software companies that don't actually, will find out through due diligence that they don't actually own the IP that they're hoping to commercialize. So you don't want to be one of those. So that's really important to get right. Same with employees and your contractors as well, just generally making sure that those are robust. So those are sort of the contracts relating to maybe the business inputs that will help with growth. In terms of business outputs, so that's your customer contracts. Again, those are really important just from a risk mitigation standpoint, and also just things around, I think at the moment too, with inflation, like having clear price revision and price increase clauses has become more and more important. Also seen as well, I guess in a third category, contracts with other businesses for collaboration and partnership. So one of the big things that I think I've seen a lot of, and one of the common pitfalls maybe across all three categories, is I guess a desire at a certain stage to say, hey, this is a really great opportunity. I want to lock it down for 10 years exclusive. Let's get everything on sign writing. And then a year later, the business is fundamentally different because it's going through rapid growth, and that contract's no longer fit for purpose and is actually a bit of a noose around that business's growth. So the sort of key takeaway and pitfall from that side of things is to always build in a parachute, have an ability to either get out of that contract or be really mindful about, say, trialing things out, testing the water. Don't commit to long terms, don't commit to exclusivity unless you've actually worked with that other person or that other business before, because 9 times out of 10 you give that away, it can be really, really hard to get back.
For that, it's interesting you're talking about contracts, because from a tax perspective, we see a lot of structures being set up and there's no contracts between any of the entities, and then people fail on either the asset concession or the R&D because they just don't have the right documentation. So as you know, Stephen was saying, just thinking about what documentation you need, getting the right advice, and making sure you're documenting things, because not having that document later could cause you not to receive, certain tax concessions, or not knowing where the IP is sitting, and that's a huge, huge issue.
I agree. So if there's only one lesson, it's please document everything. It is one of the pitfalls we all see, but thank you so much. So James, in terms of the right team, I think a question we often get is, but I'm a startup or just scaling up, how do I onboard the right team and the right people? So 2 questions, how do you onboard the right people? And secondly, what types of incentives do you see, including ESOPs, that might incentivize those people to do a good job in that business as it's scaling?
Yeah, for sure. And it's one of those things, business will say, how do I attract the right talent? And it's, well, pay more money is sort of generally the answer, but that's just not always an option for a business. So you got to look at other ways to make yourself competitive. We've mentioned ESOP, so a share option plan, and that's ultimately just giving an employee shares in the business, or their options in the business, which can convert to shares in the business in the future. The benefit of that is it's tax beneficial for the employee, and they're not getting taxed up front when you issue them the options. But typically with an ESOP, a share option plan, is that the employees have to stick around, and those options will vest over time. So you see common vesting periods, over, say, a 4-year period. And so that's going to, it's a great incentive for someone to come on board, say, yeah, I'm actually going to give you a piece of this business. You've got the option to say, yes, I'm only giving you X amount of dollars on the current valuation, but when we go gangbusters in the future, this is going to be worth a lot. So if you're in and come on board, you do have the option to make a lot of money in the future, even if I'm not going to pay you heaps of salary right now. But then once they're in, they're going to stick around as well, because they want to see the value of those options, assuming they haven't decided that they're going to go to zero, then they might get out. But as long as things are going well, then it is a great way to keep them there with you in the business. So ESOPs are a really common way to do it when you don't have the salary. But there are plenty of other things that you can do. I mean, you can just be a great business that people want to be a part of, and you can have a great culture, and there's not too much legal advice realistically about how to achieve those things. They're things that you'll just be able to know how to create a great place to work. But on the other additional sort of legal incentives that you can do, we see a lot of businesses do things like additional annual leave. Yep, we can't meet you at salary, but we can give you a little bit more time off. We can be really flexible about where you work and when you work. So while most employees out there are deciding on what's their next move based on the salary and where it's going to go, there are plenty of them who say, well, actually, my lifestyle is really important. The type of business that I work at is really important. And how I can manage, my family commitments or whatever else are important to me. So they're all things that don't necessarily cost you anything, that you can go and sell. So, Common things we see even more would be even things like paid parental leave. Still going to be something that, in a sense, costs you, but employers are now starting to ask those questions when they come on board, and they'll say, yeah, you've given me a contract of employment, but I also want to see what your workplace policies look like. So yeah, there are a lot of things to get people on board, and then I think ultimately once people are with you, as I said, yes, you just want to create a great business for people to work in, but there are some kind of structural things there. You want to make sure you've got proper, I guess, policies in place in your business to govern the conduct of how all your employees work. Because without those things, without clear boundaries about how we want people to behave at work, you create toxic environments pretty quickly. And if you're not managing all of those obligations, that's when your great people leave. So yeah, there are some structural things you can do about culture, but good culture keeps people, and good incentives, I guess, bring them on.
Thank you. And I've actually seen, from the corporate transactional point of view, I've seen investments where it was a fantastic company, proven revenue, did really well, but because it wasn't the right team and it was considered perhaps a more toxic team, it actually did affect the nature of that investment, notwithstanding it was excellent, scalable, proven revenue. So again, just emphasizing the importance of that. Thank you. The next one is exciting. So funding strategies. And actually, I might just take a quick poll. Has anyone in this room done a seed raise for their company? Right. Series A or beyond? Series B, C? No. Okay, great. So I love this question. There is so many different funding strategies and options, and there was a fantastic panel 3 weeks ago that went through that. But broadly, there's two categories. So the first, we have equity funding, which for those people in the room that have done the seed and Series A, I assume it was in the form of equity funding. And that can typically take a lot of different forms, but perhaps the most common we see is a SAFE or a simple agreement for future equity. And the benefit of that really is, particularly if you're a company that's trying to scale and you have high upfront costs, or you need a cash injection to get a product or a model off the ground, it can be a really useful tool using a SAFE because it's the immediate capital injection, but the associated equity ownership comes at a later point in time subject to certain triggers. So that might be when you get to a certain EBITDA, or when you do your next funding round or something like that. So it can be a really, really effective tool. But within that equity umbrella, we also see convertible notes, which is similar to a SAFE, but there is a bit more of a debt component. There's an interest component there. And similarly, there's priced equity rounds where you enter into a subscription agreement. That person comes straight on as a shareholder. But inevitably with equity funding, it will always be what's best for you at that point in time. So a SAFE might not be an appropriate instrument if you're looking at Series C or beyond, or you've scaled already. So I would just say there's always avenues, but just be mindful of what exactly you need at that point in time. Because again, we don't want our lovely founders giving away a whole bunch of equity, getting diluted, and then realizing I'm actually not incentivized in the business because I've given too much of my own equity away. So then in terms of debt, slightly different. I would say debt arrangements, of course, come in all different kinds of forms. So loan arrangements, lines of credits, everything like that. And typically, I would suggest there is obviously a difference with equity, because with equity, you don't have a repayment pressure like you do with a loan arrangement. So when we're doing debt work, it's typically for companies that might have a more predictable cash flow, so it knows it's able to meet those obligations within whatever debt or loan arrangement it is. But that's also a very valid way to fund. But again, I would just encourage, if you're going down a debt route, to be mindful, of course, of all of your obligations under the respective document, particularly if it's tied to a certain revenue point or EBITDA and whether you can actually make that. And then I think there's all kinds of creative solutions around funding outside of equity and debt, but there's all the non-traditional funding methods, thinking about things like reinvestment of retained earnings or a JV structure. And a JV structure can be really interesting when you're at a point where you've scaled and you're effectively in a position to pool your resources with a strategic partner that you think might offer you certain benefits, whether that's, clientele, expansion, growth. So that's also a really interesting way to do it. But all of this does come with tax implications. So Helen, I think on that note, what types of things do you suggest that founders and companies need to look at when they're considering funding from a tax point of view?
Morgan. As you were speaking, just came to mind that the amount of founders that we advise on, where when you said founders that give away a lot of the equity after not realizing, we've had so many matters where founders have realized, oh, we actually have diluted ourselves so much, and we've just done another raise, and this company now we've diluted our ownership. We barely own anything in this, particularly when you're issuing safes. Because with safes, you could keep issuing them and forget, how many have you issued, how much percentage have you actually given it away, because they don't actually own shares yet. And so it's really important, keeping track of your cap table and you knowing how much you're being diluted by. But I think from a tax perspective, it's making sure you have worked through, okay, how much do you own now and how much are you willing to give away? Because what we see is a lot of founders trying to issue themselves with further equity or trying to top up after they've given away a lot of the equity. It sounds like it's a pretty straightforward process. It's just give yourselves a few more percentages of shares, and that's great. But what it does is it results in a tax issue for you as a founder or an employee. So if you're an employee, you can be taxed under the employee share scheme rules. So as James mentioned, or sometimes it can be tax free, but for founders, because they own such a high percentage of their company, they don't fall into the tax free concessions. So the founder may be taxed as income for the value of whatever equity that they've now topped up by. It could also result in a value shift. So we're trying to move some of the equity from other shareholders away from one type of ordinary shareholders to yourselves. It could result in tax payable to all the other shareholders. So just issuing yourselves further equity for nothing to top yourselves up can result in significant tax consequences for yourselves as founders or the other shareholders. We've had to work through some very interesting matters with clients to try to find the most tax effective way to issue themselves further equity. It's not a situation I recommend that you get yourselves into because it's very expensive. You're paying your advisors a lot of money trying to work out a solution, which if you had thought about at the beginning, then you wouldn't be in this situation. So it's just thinking about, okay, how much equity do I have now? How much am I giving away? How much does that leave me? And getting advice from a capital raising lawyer, making sure you're keeping track of your equity that you're giving away. Because, as Morgan was saying, there's so many different ways of funding. And if you start losing track of where all your funding's gone, like how you've got it in and what you've actually given away, you're just in a position where you might have nothing left. And we see that quite often.
So much, Helen. We do see it quite often. So absolutely, please do keep track of the cap table as a lesson there as well. Now, IP also forms a massive part of the scalability piece. So one for Stephen, what types of arrangements or steps do you think founders need to take in terms of preserving the IP? Obviously in situations where a lot of it is, their baby in a way, of course, with a startup and a novel idea. So what steps and or arrangements do you think need to be incorporated there?
Yeah, so I think it's really important to understand, I call it what your secret sauce is. So having a real clear understanding of what it is that gives you a competitive edge. We have all the sort of stock standard stuff from an IP perspective, like your brand, your trademarks. That's sort of quite easy, low-hanging fruit. Most businesses have that in place. What I think a lot of businesses forget about sometimes is some of those like internal processes, those know-hows and things that actually give them the edge more than maybe the core product. The core product is still important. The code that you write is protected by copyright. You might be in the technology space where you're looking at patents. But I think what often gets overlooked is, we've got this really cool way of working, this really efficient way of working. That's actually what's giving us that drive and that share of the market. And that's what we really want to be mindful of and really want to protect. So, again, it comes back to those confidentiality obligations with your employees, your contractors, your contracts. You'll hear that a lot from me. But that's the sort of general idea, is that I do have a lot of conversations with clients where it's sort of like, you are maybe doing something that isn't that necessarily a novel or emerging technology, but you're doing it in a way that no one else has done before or no one else has done as good as you. And so being mindful of those sort of things as well is really important when we think kind of IP beyond its traditional sort of borders and boundaries.
I just want to touch on the IP protection, just from a structuring perspective. is a lot of the conversations that we have with startups and kind of smaller businesses is, you are developing this amazing IP. It's really where you're spending all your time and energy towards, and you're building this baby. You want to ensure you're protecting it, not just from a contractual perspective, but also from a kind of a legal asset protection perspective. So where is it sitting in your corporate structure or in your business structure? We do see a lot of structures where the IP itself or the assets that you've created are exposed to certain liabilities and risk in your business operations. And so in those cases, we do recommend, talking about should that IP or those assets be sitting in a different entity and quarantined away from all the risk that's coming in from your business model. So we may then set up a different company that's still within the same group, and that's held to be protected from all kind of liabilities and risks. So that will go hand in hand with the contractual documents that we're putting in place as well.
Thanks, Helen. And then in terms of, we've talked about founders and sort of protecting their IP up front, but then Stephen, as companies scale, there might be partnership agreements and licensing agreements to be thinking about and or presented to a company. So what are the key tips and tricks to look out for there?
Yeah, so it's quite a good one. So, I mean, there's general concepts when we talk about IP and we talk about it from a contractual standpoint. There's the stuff that everybody brings to the table. We usually call that your background IP or pre-existing IP. So it's really important you know what that is when you kind of get into these transactions and these arrangements. And then it's the challenge of carving out what is the new material, or what is, I guess, and there's sort of two categories for that. One is anything that's like completely brand new, and then there's the stuff that's kind of just an enhancement or an improvement of your own background IP. So making it really clear that you continue to own what you bring to the table. You probably should own anything that's an improvement of what you own, because that's great. You want to build on that, and that's how you grow. And then it really just comes down to the fight over who's going to own the new stuff. Now, I usually take the view that if you're paying them, you should own it. Some clients, for whatever reason, decide that they want to do it the other way. They want to have these complex structures where, we'll pay the contractor, but the contractor can own it and we'll license it back. Those sort of things don't usually look great from a due diligence standpoint. If you're thinking about investment, contracts obviously can be ended, they can be terminated, or the person on the other side of them can die in some cases, or, if it's a company, dissolve. And once that happens, you don't have that asset anymore. It's a free-for-all. So that's something really important as well. And in terms of working with, I guess, other businesses, again, on that notion of know-how and processes, the confidentiality, making sure things are only disclosed, need to know. A contract's great, and it's really good to have all that stuff there, but I think the biggest thing you can do is the actual practical mitigation. So just because you've got a contract, don't just hand over everything that you've developed if you don't need to. Still be selective, still be discretionary in terms of what you're disclosing. Keep it to the bare minimum, because yes, we can all have a clear contract. Yes, we can point to it and jump up and down and say, hey, my contract says you can't do that. But if we're startups trying to scale, do we really have the capital or funds to engage in protracted litigation to kind of prove that we're right? Because that can be hundreds of thousands of dollars. So the more you can do to kind of stop these things happening, the better.
And all too often, I think from an acquisition standpoint, during the DD process, we see the acquirer identify IP either being improperly documented, or perhaps partnership agreements and licensing agreements that aren't particularly favorable be the tripping point. And then we have to think about things like specific indemnities and the relevant documentation. And of course, if it's structured properly up front, we avoid all of that. So James, back to you. In terms of scalability, what are some tips and tricks for hiring policies as you gain more employees? And then perhaps any big mistakes you've seen companies do?
Yeah, the key thing, a lot of it comes back to documenting things correctly. And so employment contracts, if someone's a casual employee, someone's a part-time employee, a full-time employee, you've engaged someone on a max or fixed term basis, you need a contract in place. And the contract's there to protect your business. We've talked a lot about IP. There's a heap of IP protection in an employment contract, a well-drafted employment contract. There's a heap of confidential information protection in those contracts as well. There are protections about where that employee can go afterwards and whether they can gut your client list on the way out the door. All of those things exist in employment contracts, so they're really important there. They're also really critical for actually keeping down liabilities, which, you know, potential investors may not like, including things like wage compliance issues. So appropriately drafted contracts means you don't end up suddenly doing an audit, or more importantly, an investor doing an audit when they're coming to look at your business and realizing that you actually, you know, owe many employees hundreds of thousands of dollars. Those entitlements get away from you really quickly. It's just a scale thing with employees. Multiple employees over multiple hours, multiple days, the dollars get away. So you can rack up really significant underpayment liabilities, and employment contracts can really help you from that perspective. Probably the other thing is in relation to founders, I think is something we see quite commonly. Most founders don't pay themselves a wage, and that's just a reality of being a startup. And it creates a technical liability for the company, because even though you're a founder, you're still technically an employee, particularly if you've gone with a corporate proprietary limited entity. The founder is going to be an employee of that separate entity. And notwithstanding that they own the whole company, they're still entitled to minimum wages. So it's a really common liability in a startup that you haven't paid your founders or your early people. And you can be a founder who owns, you know, the company can be worth $1 billion and you own 50% of it. You've still technically underpaid yourself when you didn't pay minimum wage for every hour worked, notwithstanding that, you know, you're well and truly compensated. You just haven't been from a legal perspective. So these are technicalities. They're challenges. A lot of businesses just roll with that one and just say, yep, well, there's nothing we can do about it because we don't have the money to pay ourselves and we want to put that money somewhere else. But they're things you might think about cleaning up earlier than you might have previously planned. So when the cash does come in and you can start paying yourself, you can ultimately put a stop on that liability. They're not the types of things, and Morgan, as you would know from, you know, running many sort of transactions, these employment liabilities, you know, they don't derail transactions ordinarily. But again, they're always things that if you've got really nice employment contracts there, if you've got workplace policies in place, it's going to make your business really easy to invest in, and it's going to be one less line in a due diligence report which says, oh, hey, here are all the things that should have been done and haven't been done. There are some additional liabilities that come from things like not having an employment contract, which is it's often a surprise to people, but if you don't have an employment contract, you won't have an agreed to notice period on termination. So we've seen cases where companies gone to terminate the employment of someone who didn't have an employment contract, and they don't have a written employment contract. So the law basically says, well, there is one, it's just an oral one, and it's got an implied termination provision. And the law might imply that a termination provision is 6 months' notice. So we've seen people didn't have an employment contract, companies made them redundant, and on top of a potential redundancy liability, then had to fork out 6 months' wages to this person as a notice period payment as well. So simple document, sometimes not important, and then sometimes super important when you're trying to terminate someone's employment. So yeah, things like that, I'd say, again, a lot of it's documenting, getting those things right, make you really investable down the line.
I think that's really interesting. Just on the transaction point, I think that is right. So we don't often see it derail a transaction entirely, but sometimes it's just not a good look, for want of a sort of better legal phrase. And as James said, if it's all clean and tidy, it just avoids the sort of administrative necessity of having to do, you know, new contracts prior to completion and having the conversations with those people. And then again, thinking about the quantum of maybe entitlement liability and thinking who should pay that. So not a derailer, but not a good look is the takeaway there. Now, the final substantive question is around international expansion and entry into international markets, which is jointly for Stephen and Helen. And it's twofold. So I think the first part of that is, if a company that's scaled in Australia is looking to enter into an international market, what are the key things to think about from contracts and compliance point of view, and then the tax point of view? So maybe I'll let Stephen go first.
Cool. Yeah, I mean, there's a lot to consider. I mean, look, the most important point is, I mean, you've got to know your industry at home, and then you've got to know what that might look like overseas. So if you're in a regulated industry in Australia, there's probably a good chance it's going to be the same wherever else you go, and sort of the main, especially the common law markets like the US, the UK, New Zealand, things like that. Although from New Zealand, and I can guarantee it usually is a bit easier. In terms of, I guess, what you think about from a contract standpoint is that unfortunately there's not just one contract that rules them all. Every country has its own way or preferences in terms of what it needs to have in there, especially if you're dealing in, say, a B2C environment with consumers. So each jurisdiction usually has consumer protection laws that all require different things. A UK-based services agreement is going to look very different to an Australia one, to a New Zealand one, and the UK one, US one, where it's just a free-for-all. So it can just be a bit more difficult to navigate. Same from a privacy aspect too, which is obviously an emerging, or always been around, but it's getting more and more pervasive, and the law's likely going to change in Australia to make it every business's problem to deal with. So, you know, while there are some jurisdictions that are a bit light on privacy still, like the US, the UK and EU, obviously a great example of where that's gone the other way, and it's really strict. And so general tip would be, if you know that you're going to look at some, you know, multiple markets, trying to identify early which one is the, I guess, best gold standard. So from privacy, you know, GDPR at the moment would be that one, and then you can kind of build out from there. And if you aim for the top, everything else should fall together below a lot easier than trying to build upwards.
Thanks, Stephen. There is a lot to cover when you're thinking about expanding, but I think from a high-level perspective, the issues that we see, well, the conversations we have with clients that are thinking about moving overseas is, well, we get asked, do I need to set up a company in that jurisdiction, or do I need to set up an entity? How do I even get into that jurisdiction? And generally, I do recommend that you pause before you start setting up a company and just kind of rushing into it, because, you know, like, we're just going to get in. Because once you set up a company in that jurisdiction or any type of entity, you now have compliance issues and, other costs involved. You have tax considerations, where's the flow through of money? How are you getting the IP back and forth between the two jurisdictions? And all of these kind of issues give rise to tax considerations, because when you're moving money back and forth between countries, you have to deal with transfer pricing, and transfer pricing is, which country is taxing what funds, and is this going to be done at market length arrangements? Are we trying to move an asset across to another jurisdiction and not paying market value for it, and the ATO is going to, ask questions and start penalising you because you didn't do it properly? Do you have a tax advisor if you've now set up a company in the US and you haven't started making any money, and now you have to lodge tax returns? You're spending more money than you're actually making. So we see this a lot, where people want to expand and they set up a company, they've started employing people, not realizing they've got employment obligations as well. Each country has different employment obligations and compliances. We dealt with this person who had a German employee, and they didn't realize that they had multiple obligations in Germany, even though they didn't set up a company over there. They were just engaging this German employee, and we got advice from a German advisor who said, now you have to pay a bunch of superannuation, life insurances, social security payments, and various types of taxes. So it was a huge surprise for our client, and so I just think it's really important, if you're thinking about moving overseas, is don't rush into setting up a company or an entity. If anything, if you want to get started, is start outsourcing things. So if you can, use an employer record, like Deal, for example. They're really great because you can just get them to employ someone, and they take on all the obligations in that jurisdiction, and it'll at least get you started. And yes, there's a bit of money that you have to pay up front, but you don't have to deal with the compliances, and it potentially could be ongoing. And it makes it really difficult trying to unwind if it doesn't work out. So you put a lot of money into that country and it doesn't work. So now you're trying to get out and you've got to pay a bunch of bills. So that's my advice, is just get advice early. Don't set up a company first. Take your time, outsource everything, and then make a plan on how you actually want to enter the country, and like Stephen was saying, making sure you looking at the compliances and contracts and putting those in place.
And now, just to wrap up, I'm going to ask everyone for their final tip to be mindful of in scaling. For me, I would probably say scale with view to acquirability at the very end of that. So if you put yourself in the mind of a purchaser, whoever that may be, think, oh, would a purchaser look at this company and DD my company and say there's way too many skeletons or greeblies in the closet that I need to fix? And if the answer is yes, then you probably do need to fix them. But that would be my tip. So Stephen, we can go down the line from you.
Yeah, one or two? This one. Cool, thanks. I think my one would be, and it was just on the top of my tongue, is from a scalability standpoint, it's the point I sort of raised earlier around, making sure that everything you enter into, every arrangement you commit yourself into, every knot you tie yourself in is fit for purpose and is going to be fit for purpose for the next sort of few years. And if you can't see it as being that way, or you talk to someone else and they can't see it as being that way, then build that parachute and have an ability to get out of it, or just trial it out and then see how it goes. And even if it's just a contract that you renew every 6 months, that's way better than locking yourself out for, say, 10 years.
I actually thought you were going to say document everything.
Yeah, I feel like we drove that point home tonight.
Yeah, I was like, I feel like it's a common theme tonight, document everything. So my tip for tonight is getting the right structure in place from an asset protection and tax perspective. So just getting that advice from the beginning and, having an understanding of what your business model, that you want to look like and what your exit strategy is. And then speaking to your advisor as to what the most appropriate structure is for you. It may not be a company, but it is the most common. So it might be the structure that you use, because getting that structure right obviously gives you the tax concessions that you may want, giving you the flexibility to hire the right people and give them the equity and the fundraising, and also expansion if you're moving domestically or internationally. So yeah, my advice is just getting the right structure in place and getting the right advice for that structure at the beginning.
Yeah, mine actually is document everything. So, but no, it's probably about from an employment perspective, get the right structure early. And it's probably the case with everything. I'd say, and a key takeaway, it would be talk to these guys more than you talk to me. From if you're a startup, this stuff is probably more important and where you need to spend most of your time early stage. But there are some really easy wins from an employment perspective, so get them right early. You can get your house in order on an employment basis with just a couple of pretty simple documents. But yeah, it is thinking about if you've got the right people, how do you incentivize them long term, and that's looking at all of your kind of incentives like ESOPs are a great place to start.
So much, and we've got a few of the key takeaways just up on the PowerPoint behind me, which we've broadly covered off, other than document everything, which we can add to that list. But we'll take some questions shortly. But on the topic of documenting everything, we did also just want to talk to the LegalVision membership. So as a member, you get unlimited access to 100 plus of us, which I think is pretty cool. And effectively within the membership, it's like having an in-house counsel for a fraction of the cost. You get unlimited document review and drafting within that. You also get unlimited domestic trademark registration, and you get the unlimited ability to book in 30-minute slots, as many as you want per week, but maybe don't overbook yourself with any of us, to talk to any of us about anything at any given time. And if we're not the appropriate person, we will then direct you to whoever we think the appropriate person is. And then in terms of tonight, we are offering a free complimentary consultation for all of you. If you'd like to scan the QR code, please book in with us. We can discuss what you need. If it's something hairy or if it's something really simple, we can be on deck. So thank you so much, everyone. And I think it's question time. So we'll get a mic out into the crowd and get some questions.
Yeah, that was really a very good summary of sort of beginner's guide to getting started. My question related to funding. do you see many A class, B class, C class shares being issued these days as part of funding arrangements?
There is yes to your question. In terms of issuing class shares, it often depends on the structure of the funding arrangement. So, we certainly see things where the intention is to issue Class A preference shares because they have specific rights attaching to them, which might be, if the company goes belly up, they get a certain proportion or a liquidation preference right if that does happen, or it might allow certain board or veto rights attaching to those. So my answer is yes, you can effectively structure the class shareholdings however you want, but the more important point of that is just ensuring the rights attaching to those shares, those class shareholdings, are commensurate with what you're actually trying to do. And you're very clear on the capital table around the classes of shares you're issuing at any given point in time, as we said, so it doesn't all of a sudden get away from you. I've seen X class shares, so it went A to X, and I don't know that's necessarily a clean arrangement. But that said, the lesson there is the capital table and making sure the rights make sense and you're not issuing class shares unnecessarily just for administrative purposes.
Hi, you mentioned about the IP entity and the operating entities. So what are the practicalities of, down the track having to, and the costs really, around switching it in some of the, all of the IP from the operating entity into the IP entity?
So if you were to start with just a single entity and everything was in there, and then you're looking at, moving into an IP company, we generally see it as a holding company. So that holding company would ultimately wholly own the operating company. And it's a two kind of step process, but you do need to set up the holding company, and all your shareholders would then need to transfer their shares into that new holding company and essentially do a share swap. So that's part one. That part one does trigger off a taxing event because all your shareholders are transferring ownership to a new structure. So if there are rollovers, so there are certain tax rollovers that can apply when these types of restructures happen. Most of the time they do apply, but if they don't apply, then all the shareholders are going to have a CGT event and tax payable on that event. The second part is then moving the IP. So you have to then move the IP from the operating company to the holding company, and that again is another taxing event. So there are other types of rollovers you can utilize as well. But if you don't meet them, then that's another taxing event that the operating company has to then pay tax on. Generally, for a lot of startups, their operating company, like the IP itself, the cost of that is going to be more than the value of the IP. So a lot of times there's going to be no tax payable because the value hasn't exceeded the cost of how much you've spent on already, or you haven't launched yet. This is why it's really important. I do recommend just getting that structure in place before you have to start moving things around, because just because you might not have a tax event, as in like a tax liability for your shareholders or the operating company, getting the tax advice is going to be a costly process. So if you just get that right at the beginning, you don't have to get the tax advice. It's already there. Something else that we like to recommend is consolidating the structure at the beginning. So you tax consolidate it so that the two entities, so if you have a holding company and an operating company, you consolidate it for income tax purposes, so it's treated as one taxpayer. It means that then you can move your IP back and forth between the two entities. There's no tax implications between, in that transaction. It also means from an administrative perspective, you have one taxpayer. You're only lodging one tax return. So it does save you cost over time. In regards to other practical costs, setting up two companies, it comes with costs. You obviously have to set up two companies and pay the cost in doing that, and then ongoing cost of running the two. So there are ASIC fees. I think they're about $350 or $380 each year for each of those companies. So that's just something you have to keep in mind. But those costs may be minimal compared to the tax consequences later. Does that answer your question? Yeah.
Hi. Thanks firstly for quite a informative session. I have two questions. One is from a legal standpoint, and second is for Peter from a people standpoint, right? From a legal standpoint, okay, I'll just give examples in terms of, say, a Facebook or a Snapchat, uh, some of the world's largest organizations today, right? You've had legal issues between the founders even before they went to Series A. So so does that happen? Is it relevant out here in the sense in terms of have you had scenarios of founders breaking apart during this kind of scenarios? How did you handle it in spite of multiple times you've been telling this multiple times, documentation? I'm sure you have all the docs out there, right? You have all the legalities, but you have a Facebook type scenario or a Snapchat type scenario. You have founders just splitting apart and going highly legal, going to the worst possible ways, and finally settling it out of court. Number one, that was the first part. Peter, in specific to a point you raised, I've faced this issue personally, right? That's why I want to check how it works with you. So one is, you said that startups want to hire people and the incentive is ESOPs, stocks, RSUs, whatever, right? You also said that you hire them on contractual basis or short-term basis. Now, how does that match? Now, if I'm hiring someone on a short-term basis, why would I possibly have a structure of an ESOP or this thing? I'm looking long-term right now, but I want to attract talent. So I'm still stuck at, okay, I'll have to pay you 1.5x the market rates, possibly, if you're a techie, but then there's no guarantees of still staying on. So how do you manage that in the current market scenarios?
Yeah, so I mean, you're totally right. If you were going to bring someone on a short-term basis, you're probably not also going to offer them options under an ESOP. You still can. There's nothing preventing you from doing that, and we see it often with, I guess they're kind of like side-by-side early consultants who will say, I'm actually not going to get paid, but I'm going to help you get started. And in return for that, you will actually give me something under the ESOP, which it still takes 4 years generally in order for all of those options to vest. But that's sort of a long-term payment you're giving me just for what I'm doing to help you at the start. And sometimes that might be, I'm just getting you in touch with the right people. I'm doing a bit of matchmaking. I'm doing some introductions, or I'm just helping you get off the ground, something like that. But yeah, equally, if you are going to engage people on I only want you for a short term, I don't want you here long term, and I don't see you as someone who's sort of critical, or I can afford to actually just pay you because I don't want to part ways with those options, which eventually become shares potentially. Then you don't have to have an ESOP at all, and if you do have an ESOP, you can be very selective about who you actually decide to give options to under that plan. Not everyone's going to get them, so. They don't have to be one and the same. You don't always have to have an ESOP sitting there, and you can use it for the short-term engagements, but mainly if it's just in lieu of some kind of salary is typically when that would kick in. But otherwise, it sits side by side and offer of permanent employment, which is employment until we terminate or until you terminate, which is a common way, for say a full-time employee to be engaged. You might think about offering an ESOP there as well, but certainly no obligation to give it at all.
And I'll just talk to your first question. I think we've probably all had experience with the founder dispute pre-acquisition or whatever it may be. But the unfortunate answer is yes, we do often see scenarios where there has been a dispute or a disagreement. And perhaps I might just talk to the acquisition point of view. So in a transaction, if the company's been identified by a purchaser and they want to buy the company, but they've identified there's a founder dispute there, we would typically, there's all kinds of ways to document it, but on the purchaser side, often they will say, sorry, you have to buy out Joe Bloggs before we can actually enter into this transaction. And in order to see that, we need him to sign a deed of settlement and a deed of release. And that effectively is a condition to our investment and or acquisition of the company. So you have to sort that out as amongst yourselves, whatever that looks like, and that is a condition. So where there's particularly toxic relationships, we do see that happen. Relatedly, there are, of course, companies where there are multiple shareholders and there may be a dispute from someone saying, I actually don't want to leave this company and sell my shares. I'm keen to stay on, so I don't want to take up this third-party offer. And that's a really interesting one. So when we document constitutions and shareholders agreements, we always deal with the risk of what we call green mailing. And green mailing is maybe a smaller shareholder or another person that says, no dice, I'm going to hold up the sale because I don't want to. But the way we deal with that is via drag along mechanisms, which sounds very aggressive, but the legal name for it is dragging someone along. And under the constituent documents, which goes back to the point around getting them in place early, you say, sorry, actually, we're dragging you into the sale regardless of what you say. And effectively, it's almost a forced exit. And we don't like to see that either because, you know, sometimes there is tension. But of course, if it's in the best interests of the company and the eventual acquisition, we sometimes do see drag rights. But I might pass to Stephen if you have anything to add on the disputes piece, or anyone else. We've probably all had experience.
No, I was just going to add that, I mean, these things often, you know, when they do blow up, it's because they don't have those documents in place. And that's obviously from a, you know, about the point of processes and things and knowledge is that if you don't have those documents, then there are no things like non-solicits, non-competes. And you do sometimes end up with those scenarios where, you know, maybe 2 or more founders have all, you know, it's all been blown up and they all go separate ways and they all start working on competing ventures because maybe they, you know, were 4 friends who started in the same industry to solve a problem in that industry, and they all have their own ideas and ways on it, but there's no contractual restraints or anything there to maybe stop them all competing with each other. So that can kind of be a bit messy as well when those things don't get resolved or documented up front. Documented again.
One last question.
Probably a question for Helen. In terms of ESS, do you think that the implication of CBT or even FBT is more worthwhile or more, you know, worthwhile to be in it instead of paying the employee the salary?
So you're asking if it's
Employee share scheme.
yeah, so under the employee share scheme, is it better to issue employee share schemes even though you might have CGT or FBT issues, and then paying the salary? So as I mentioned earlier, if you're a startup, under the employee share schemes, you can meet certain conditions. So if you're, you know, less than 10 years old, you're issuing the employee less than 10%. The equity that you're giving to them would generally be tax-free. So that means for the employee, ordinarily they would have to pay tax on that, you know, the shares or the equity. But if they meet those conditions, then they don't. And the benefit of the startup concession that you're getting there is you get your capital gains tax, you know, discount from the beginning as opposed to waiting to when they convert into, you know, you still get the 12-month discount, which sounds like you already know about, from the beginning. So it is a really great incentive. And if you can access that concession, then I would do that. And it is a really good incentive. You know, if you can't afford, like you don't have a salary, then an ESOP is a great incentive for employees. They can be structured in so many different ways. You know, James was talking about, you know, a 4-year vesting period, but you can have so many, we see so many different interesting designs on employee share schemes, depending on what your intentions are. It may be that you're trying to incentivize this person for the short period, or you might be looking at, you know, bring them on as someone that's going to be in the business for a long time. And you'll have certain types of exit strategies and things like that. In regards to the FBT point, so with employee share schemes, it actually is excluded out of the FBT provisions as well. So if you fall into a genuine employee share scheme under the tax regime, then we're not dealing with FBT. The employees generally get the CGT concessions anyway. So from my perspective, an ESOP is a great incentive, and those other 2 tax considerations are not really issues if you don't have the money. But like, you know, James was saying, if you have the money and you don't actually want this person to stay on board, you know, as a option holder or a shareholder, then don't issue them options. Don't give them equity because you might not want them to stay on long term. Yeah.
Everyone, networking time. So thank you.